So today we're joined by Norman Lamb of 9 St John Street to have a Q&A following a recent case we were involved with in relation to a funeral dispute.
So let's get started. Norman, this case is about an injunction. Please can you tell me what form an injunction could take?
Broadly speaking, there's two forms. We have interim injunctions and final injunctions. Final injunction would be decided after the hearing of usually a trial, so all the evidence has been considered and the judge makes up their mind. An interim injunction is quite a powerful tool because it's more of a prohibitory step before evidence has been heard to maintain a status quo set by the court. They can also be prohibitory and mandatory, just like a final injunction. So even before trial has started, you can have a court order saying you must do something or a court order saying you cannot do something.
So how would the other side know that this sort of injunction application has been made against them?
They come in two forms. The first is on notice, so the other side would be given the heads up about the hearing. They'd be given the full opportunity to attend and make representations for their side, and the judge would hear both sides and make their decision. In extreme situations, so emergency cases, what we have are without notice applications. Essentially they are one-sided, so a great deal of trust is placed in you from the court to get the facts correct and be open, full of frank disclosure. But the other side won't know that hearing has taken place yet. You can give them an informal heads up, but they won't be in attendance usually. They're used by the court, like I say, in very extreme circumstances and emergency situations. In the most extreme cases, they can even be dealt with by telephone with you and a judge.
What are the consequences of breaching an injunction?
They're quite simple, really. Deliberate breach is contempt of court. You could be looking at a large fine or even imprisonment.
So once we've made this application and filed it at court, how quickly is it usually put before a judge?
The application is filed with a certificate of urgency, so the court staff will find the next available slot. Usually it's either same day or next day, but in extreme cases it can be heard relatively imminently by a telephone.
So once the judge has ordered the interim injunction, what usually happens next?
We would want to make the interim injunction final, but in order to do that, the court would want to see some substance behind why it should do that. In these urgent body dispute cases, that usually takes the form of an application pursuant to Section 116 of the Senior Courts Act. What that does is seek to pass over the person who would ordinarily be entitled to letters of administration or a grant of probate. The High Court will grant such an application if, by reason of any special circumstance, it seems necessary or expedient to do so.
So in these burial disputes, what's the starting position? Who usually gets to make the decisions about the deceased body?
The court starting point is, it's important to note that there's no property in a dead body. So the court isn't looking at ownership or proprietary rights, they're looking at who has the rights for disposal. Ordinarily, it's the person whose roof the deceased dies under, and in practice that's usually a hospital. But there is somebody with a better right, and that would be an executor or a personal representative of the estate.
So what happens if there is a will?
With a will, it's quite straightforward. It's whoever is named as executor. That executor or executors will have the right from the date of death.
And what happens if there isn't a will?
If there's not a will, it's not as straightforward. It depends on whether there has been a grant of letters of administration yet. If there has, it's the person who's named in those letters of administration. If there's not, it gets a bit more complicated, and the court would look at the non-contentious probate rules and determine who ordinarily would have the right.
So what are the key points and recommendations if you find yourself in a burial dispute?
First of all, check whether there is a will, and ordinarily a will may include a clause expressing the testator's wish to have a certain type of funeral service. That would help steer a court. It's not binding on them, it's not binding on an executor, but at least it shows the intention of the deceased black and white. For those who die without a will, it's a little more complicated and very fact specific, and I'd be getting in touch with FORB solicitors to figure out what the best way forwards. That would probably be the Section 116 application, but what FORBs would do is help you look at the documentary evidence, tell you things to look out for, and essentially prepare a good case in order to have the best chance in court.